We're here to discuss the legal options for healthcare decisions and practical issues. We have 4 very esteemed panelists who are very accomplished in their respective areas. And we don't have a lot of time this morning, and there is an awful lot of material. So I'm going to introduce the panel members ever so briefly, and they've all said that that's fine. And I encourage you to look at the bios and the materials you have for further information, and or Google them all, because they all have websites and you can see their very impressive resumes. So our panelists, first to my right is Kathleen Cunningham. Kathleen is the Executive Director of the BC Law Institute and Canadian Centre for Elder Law. And next to Kathleen is Krista James. Krista is the National Director for the Canadian Centre of Elder Law and the BC Law Institute. She's a staff lawyer there. Next is Hugh McClellan, who's a partner at McClellan Herbert Lawyers, and Hugh specializes in estate and elder law. And our final panelist is Dr. Karen Gelman, who's a medical oncologist with the BC Cancer Agency. Before I hand this hour over to our panelists, I just want to set the stage a little bit for what they're going to talk about. There are substitute decision-making laws that in our province and across the country and other jurisdictions that provide for how healthcare decisions are made when a person can no longer make them for themselves. We also in British Columbia have some supported decision-making. And the question is how is this scheme working? And that's really what these 4 are going to talk about today. Does the public know the options that they have? Can substitute decision makers or supported decision makers be found when they're needed? Are they being heard? In British Columbia, we have a registry for representation agreements called NIDAS. I'm sure you've heard about that. And what role does NIDAS play is another issue. Kathleen's going to talk about the legislative scheme. Krista's going to share some of the research out there on supportive decision making. Hugh's going to talk about the perspective of a lawyer and what he sees his clients looking for. And Karen's going to discuss what happens from the hospital or clinic perspective when someone is required to make a healthcare decision. So I know that this is going to be a really interesting hour. You're going to get a lot of great information. I am going to ask that we have all the panelists speak and then save the questions for the end. And all going well, we should have 15 or 20 minutes for questions. So on that note, I'm going to pass things over to Kathleen.
Just before I get started, this conference has people from many different walks of life and different parts of the country. So just so that we know who you are, how many people are not from outside of BC? So just about everybody's from BC? Anybody from the States? Okay. Anybody from outside of North America? Okay. Okay. And then how about lawyers? Any other lawyers in the group? No? Okay. Physicians or nurses, healthcare providers? Okay. And then my big question is, how many of you have your own substitute decision, powers of attorney, representation agreements? How many of you have those in place? Wow. Pretty good. Very good. How many of you have had to make decisions for other people? Okay, so some of what we have to say today. And is that healthcare decisions or financial healthcare? Okay. Okay, so hopefully what I have to say is, what we have to say is not new to you, or will be new to you, or at least shed some light on what we have. Now I got to figure out how. Okay, so we have the panelists. Jennifer talked about what we were going to be doing or talking about. So when I think about healthcare decision making, I put it into a bit of a hierarchy where it's you decide, a substitute decides, and if you can't decide and a substitute's not there, then there's some default rules. So generally, when it comes to healthcare, the patient is the one who will give consent, will make the decisions, and they make that at the time. Where the person has diminished capacity or wants some help, they may have a supporter, and that can be an informal or a formal role. But again, somebody is helping you, the patient, make decisions at the time. The other way that you can control something is through what we call in BC an advance directive, where you give specific instructions for how to deal with certain decisions. A substitute is when you have appointed somebody else through a power of attorney, representation agreement. We'll get to terminology later, but you've appointed somebody to make decisions for you, or the court has appointed a guardian. In BC, we call it a committee. And then there are default rules on what to do when there's an emergency or when there is a decision to be made and there's nobody around to make it. So I've spent my career doing teaching estate and trust and power of attorney type laws across the country. We have 10 provinces, 13 territories, and one of those provinces is a civil jurisdiction. For those from the states, you have even more jurisdictions. I think 13 is enough. But it complicates this area, and it really gets complicated with healthcare decision making. So it's the provinces and the territories that they make the legislation about decision making. Who can be appointed and what can they do? Healthcare consent legislation comes under the provinces. Who must have consent and when? And the jurisdictions aren't the same. The terminology, the scope of the authority really starts to vary when you get to personal decisions and healthcare decisions. Powers of attorney, generally, that's pretty standard. It's your financial, legal matters. We're familiar with those, but when it comes to healthcare, it gets much more confusing. And then there's a problem of interjurisdictional. Just because you made a document in Ontario doesn't mean it'll be recognized in BC, or if you go across to the States, will it be recognized there? So these are all issues that do happen, do come up, and so it's helpful to at least understand that this is the way it is. The criminal code also has some impact when it comes to healthcare decision. We're all familiar with the legislation being introduced on physician-assisted death. We're not going to talk about that today, but within the criminal code, there are things that cannot be done, or it's a criminal offense. So that affects what healthcare decisions can be made at times. And then just a note, in the U.S., similar regimes, the states pass most of the laws, so you get these, crossing jurisdictional issues. There is some good news on the horizon. The Uniform Law Conference in the U.S. and the Uniform Law Conference of Canada are looking at proposing uniform provisions that each jurisdiction could introduce to their legislation so that there would be interjurisdictional recognition. So those uniform codes are coming out. Hopefully we'll see them all this year, but that doesn't mean those are the law. That's just recommendations from uniform law conferences. Each jurisdiction has to then adopt it. The good news is in BC we do have some interjurisdictional recognition. So when you came in, you received a handout. It's basically just a takeaway for you, but this slide is a quick summary of, just shows you all the terminology that exists in this country, and that's just a sampling because it's not all 13 jurisdictions, and the authority that each one has. So the handout that you received has more information on that, just for your information and just to illustrate where the laws come from and what the terminology is, because we have committees in BC and guardians in other provinces. We all have attorneys for power of attorney, but we also have something called a representative. In Ontario, they have a power of attorney for personal and health care, so they call it a power of attorney. So it gets really confusing. So my big message, if you take nothing away, is make sure you're talking apples and apples when you're talking to somebody else. And if someone's come from another jurisdiction and they say they have a document, make sure you know what they're talking about. And don't assume that because they have a healthcare decision-making power from another jurisdiction, it's the same as it is here. Don't assume that it'll be recognized. Those kinds of assumptions just can't be made. So when it comes to mental capacity and making healthcare decisions, the general rules are that we all have a legal right to make our own decisions. A mentally capable adult must understand the relevant information to the decision that needs to be made and the consequences of those decisions. And there's a presumption of capability, and we certainly have that presumption here in BC, and I think it generally applies across the country. So when it comes to healthcare consent in BC, my message is know the scheme in your province. This is the scheme in BC, and I think most of you are from BC. So the adult must consent unless they're The healthcare provider gets consent from the adult, not someone else. The There's supported decision-making, and Krista's going to talk a little bit more about how that's been, what our research shows on how that's working. But if a supporter is around, whether it's formal or formal through a representation agreement, that would be the next way to make the decision. Then we move into substitute decision-making if someone's incapable of deciding. So you have the committee appointed by the court under the Patients Property Act, or the we have representatives under the Representation Agreement Act. Just to complicate things in BC, we have a Section 9 representation agreement, which allows the representative to make any healthcare or personal care decision unless subject to a few regulations and what you put into the document. A Section 7 representation agreement covers personal and healthcare as well. There's a few limitations on what can Section 7 representative can decide. Then we have the Advance Directive, which is giving specific instructions for specific care. Those documents, to be legally binding, have to be prepared in accordance with the rules and the legislation. And then we have a temporary scheme, or a default scheme. And it's a temporary we call it TSDM, temporary substitute decision maker. So if there's nobody, if the patient can't make a decision, there's no supporter to help them, there's no substitute, there isn't time to go to court, and one medical decision needs to be made, consent can be given by a temporary substitute decision maker. It's important to know those rules, because once you know there's a default, someone might say, well, if there's default rules, I don't need one. But you need to know what the default is, because maybe that will be the reason to go make a representation agreement in this province. Because the rules are, the healthcare provider must go through a hierarchy. It starts with the spouse, then it goes to the children. So if there's 4 children, just any one of the children. If they start fighting over which child it should be, the healthcare provider can't skip to the parent or whoever's next. They actually have to go to the public guardian trustee, who can then choose somebody to make the decision. And if everybody on the list, if there's nobody on that list, then the public guardian and trustee will step in and make the decision. So we have a default scheme, but people might not like where that default scheme would be. And if you know who you want to make that decision, and it's a certain child or it's a friend, you need a representation agreement. We do recognize pre-expressed wishes. So one of the, we all have heard of living wills. In the US, there is legislation that actually acknowledges living wills. We have advanced directives. So if somebody has gone onto the internet and found a document called a living will and prepared a living will, that's a document. It's a pre-expressed wish, but we do recognize pre-expressed wishes when decisions are being made. And as I said, legislation provides for emergencies, and there are a few exceptions. I'm not going to get into that. But that's just to give you an idea of, we actually have a very complicated scheme. It was supposed to be simple back in 1990, but we have what we have. And then just a final note, if the document, like a living will, is not recognized under BC law, or some sort of a directive has been prepared, if it's not recognized, it can still be used to express wishes. Indicate your wishes, but we do have extra jurisdictional recognition in BC. So a document that is like a Section 9 representation agreement will be recognized. We don't recognize something that would be like a Section 7 representation agreement or the BC Advance Directive. So those documents have to be prepared here in BC. I think that is it. I'll turn it over to Krista.
Now, Kathleen just compressed about a 3-hour presentation into 10 minutes, so I know it's a lot to absorb. I'm going to put my clock here to try and keep me in line. I have 12 minutes. I'm going to compress a lengthy paper into 12 minutes. And so for those of you who are wanting to take notes or get more detail, I'm just going to tell you right off the bat, the whole paper is available for free from our website. So you can go to our website, which is www.bcli for BC Law Institute.org/CCEL. And if you go look at our projects, there's a project on the lived experience of supported decision making. You can download the whole paper. Although it's long, it's fairly plain language, and there's lots of stories in it to help make sense of the material. And all the themes that I talk about today are in that paper. I'm just going to try and hit some of the key highlights that I think are really important for understanding this issue. So Kathleen's gone over the legislation across Canada, and again, this presentation is also going to take a national perspective. Hugh will do, I think, a more particulars dive into BC, but I'm looking at more a national perspective on supported decision making, and our work is sort of comparative and conceptual, and we want to highlight sort of issues and problems. The presentation is called supported decision making because we're starting from the premise that it's a good thing. How can we help it to be more supported in Canada so this option is more available? So I'm just going to say a second about the Canadian Centre for Elder Law. I'm a lawyer by training, but I don't represent folks with their personal issues. We look at the system, at systemic change at the CCL. So we do, as I said here, research, law reform work, education. We produce a lot of tools. Just about everything we do, we make available through our website for free. So feel free to peruse, download, print, make copies. Say it's from us, but you can make 500 copies and share at your conference. We want the information kind of out there. So what is supported decision making? We're talking today about supported and substitute decision making. So supported decision making is, in a way, it's not one thing there and one thing over there, and the two things are totally different. I think of them almost more as on a continuum, with substitute decision making being at one end and extraordinarily supportive decision making being at the other end, but decision making is often falling somewhere in between. And as I think Kathleen mentioned in her presentation, with the way legislation is going in BC, and there's an option, there's a duty to consult with your the person you are a substitute decision maker for. I think substitute decision making is going to start looking more and more supportive and have to under the law. So on this slide, we've got some bullet points which really start talking about what supported decision making is ideally. So the person retains their full legal capacity. The other person who is with them is a helper, is a supporter. They still make their own decision. There's a relationship of trust between the person. The person who's helping you is someone you chose. It's not foisted upon you by a judge or anyone else. Usually supported decision-making happens more as a network than in being one person with somebody helping. It's like a circle of support, we often say. And the person has generally an authority to sort of communicate for the person they support, but also to help them. Those two things are often together. And this is a relationship that's chosen. It's not generally a situation where someone gets paid to be a supporter. And it's usually friends, family, loved one. It could be a caregiver who's changed her role and become a helper because a relationship has developed. Just in terms of saying some things more principally about supported decision-making, I think it's important to understand that the right to make your own decisions is really, it's kind of a universal right of citizenship. We all are supposed to have this right, but disability, and I think underlying this theme of this presentation is notions of disability, right? Disability can get in the way of your rights, but it's more often perceptions of disability and what we think a person isn't capable of because of a cognitive impairment or an intellectual disability. So supported decision-making legislation really arose to support and validate the relationships that really already existed there to help people live the most autonomous lives possible. Now, the notion of substitute decision-making and supported decision-making, when we talk about rights and citizenship, we think, it's your right to make your decisions. But I think another point that's important to raise when we talk about supported decision-making is, in reality, decision-making is an inherently social activity. Most of us make decisions together, especially those big ones. We consult someone we love or trust. Legislation can recognize these relationships, but the idea that only people with disabilities need supported decision-making is a little bit of a myth, because we all make decisions together unless we live alone on an island or nobody likes us. So the Canadian Centre for Elder Law, we got some funding in 2014 to do some work on supported decision-making. Basically, the Law Commission of Ontario had a funding to do a project on capacity and decision-making, and they invited papers. And we pitched to them, we want to write a paper on supported decision-making in Canada. And they agreed to give us this money. Now, why did we want to do this work? And part of it is, I would say, the timing. Supported decision-making is getting more recognition internationally. BC has really been a trailblazer with the representation agreement legislation coming into effect over 15 years ago, and BC is being looked upon as a model. So we thought now that people are looking at copying BC more and more, it's really important for us to look at how is it doing? How is it going? How can we make it even better? Now, the United Nations Convention on the Rights of Persons with Disabilities, it also was adopted in 2006 and ratified by Canada in 2010. And a lot of us who look at Article 12 of the CRPD say this imposes a right on signatory states to create more mechanisms so folks with disabilities can have more autonomy about their own decision making. So these international instruments are starting to impose obligations upon other countries, and supported decision making, then the BC model becomes something everyone's looking for as something that can help them live those obligations under this UN convention. Another piece is it's getting more popular and more discussed in the States, and what we've seen quite recently is the US now has a National Center for Supported Decision Making. I think it's just last year that it was started. So we got this funding for a very short project, and I'd like to underscore it's a scoping project. We had 4 months to do the work, so that's not the thorough investigation that really needs to be done. And we're hoping that we can kind of jump from this scoping to doing a deeper dive in some of these issues. So our work included in this paper, you'll see a summary of legislation across Canada that touches on supported decision making. Now, we looked at 5 jurisdictions. We looked at the Yukon, BC, Alberta, Manitoba, and Saskatchewan because there's some kind of mention of supported decision making in their legislation. Manitoba, it's really just a mention. I would say there's more 4 jurisdictions in Canada that have legal recognition of some kind of supported decision making, but it varies a lot. In a couple jurisdictions, you really need to go to the court to get it. In Yukon and BC, it's all done by agreement. So there's a lot of diversity in terms of what we say about legally recognized supported decision making in Canada. So our work looked at legislation, but really we were talking to people about the experience of supported decision making. And if you look at the slide, we did telephone interviews with 20 key informants across Canada. These I think of as more the professional experts, folks working for the public guardian trustee, health folks, lawyers, notaries, people who are dealing with it professionally. And then we spoke to 10 people in BC who this is part of their lives. They need it or they support someone. So I talk about those people as experiential experts. So the questions we asked, I'm just going to check my time. So I've got about 4 minutes. So the questions we asked are, how is it working? What are the roadblocks? How can we basically do it better? So I'm just going to give you a sneaky peek at the finding, and they're all discussed very clearly in the paper with a nice summary section at the beginning, so I can skip the whole paper. So most importantly, I think that everyone said it's a great thing. Theoretically, it's a great thing. No matter what we say about how it's working, it is so important to make supported decision-making available to folks. Even the most conservative people we spoke to said that. What the key informants, so when I say key informants, these are more the professionals we spoke to. They said it works best with someone who already has a circle of support around them. And one thing that really comes out from that for me is that it means that supported decision-making is working best in a way for the people who need it the least. We need to find ways to make it more available to people who don't have as many natural support networks surrounding them. A lot of the things that are making it not work have to do with discomfort for the professional sector about using it. And so I'm highlighting a couple sectors here. So the folks who, like lawyers, notaries, who might be helping people write the agreements, they're not as used to them as powers of attorney, so there's some reluctance often to help people create these tools. Hugh is certainly the exception. Third-party financial institutions can be a problem. They're not used to representation agreements, and they're less comfortable with using them. Now, one of the things that underscored, I think, from every single person we spoke to is that there's a lack of understanding of supported decision-making and often actually substitute decision-making as well, but particularly supported decision-making. There's a huge need for training and education. There are concerns about the cost of formalizing supported decision-making. As a result of that, people often get broader powers and go for guardianship. And I think this is particularly true, not as much of BC, but of jurisdictions where you have to go to court to get a supported decision-making document. So because it's so expensive, they kind of get all the tools at once. And so the helper gets the power, wants to get ready to be a guardian right at the beginning, so you don't have to go to court twice. So the formalized approach through the court kind of imposes some barriers itself. I'm just going to shut off my timer so it doesn't go off. Sometimes people are supported decision makers, technically, but they're really using their tool for substitute decision making. I think this speaks a lot to the lack of knowledge. In terms of people who are using supported decision making, they've said it's confusing how to get one. We want to do it, we don't know what to do. There are lots of barriers. Again, they say it's a network, and I'm going to stick on to the next slide because I think this one is most important to me. There's a tremendous amount of frustration. So especially in dealing with healthcare providers, hospitals, income assistance, people are saying they have this instrument that's supposed to be a tool for supported decision making, but nobody knows what it is, has ever heard of it, and wants to acknowledge it. So what you have is situations like a person who is a supported decision maker for someone with disabilities and is dealing with the welfare office. They come in with their rep agreement and they're told, no, you have to sign our paper. It's like, well, I have a legal document that's recognized by the courts, but I got to sign your other little form to be able to support this person. So the government agencies, the systems are not adequately set up to recognize a legally recognized document. And this puts in huge barriers. So I want to talk for a moment about slippage. We found that supported decision-making and substitute decision-making are not totally distinct practices, and one reason for that is slippage, and that has to do with the lack of education. Usually it's not poor intentions, it's people are wanting to be as helpful as possible, but because people don't really necessarily know what supported decision-making is when they enter into that agreement, there's this slipping into substitute decision-making, which they get more easily. And I think part of the problem, with no disrespect to the folks who worked really hard on creating the legislation, is that the actual word representative sounds like you're there for somebody else. It doesn't sound like helper. And so we've seen in other jurisdictions that have created legislation a bit of a movement toward using supported decision maker. My sense is that's a little clearer, but I think one of the challenges with the representation agreement regime in BC for supported decision making is we've got one law set up to create both substitute and supported decision makers. So it's hard often for someone on the receiving end or someone acting to know, which am I? Who is this person? We call it the same thing, and that creates confusion. Often supported decision-making is used as a gateway to substitute decision-making, and that's often where there's someone with a degenerative condition. So you're a supported decision-maker as long as the person is capable of participating, but then you're ready to step in as a power of attorney or as a substitute decision-maker using that rep agreement to make decisions for them when they can't do it for themselves. And then I think also the other area where supported and substitute decision-making are happening at the same time with the same network of people is you may have a supported decision-making for one part of your life, say your personal decisions through a rep agreement, but then you might have a substitute decision-making agreement alive at the same time, a power of attorney for your more complex financial decision. So they're kind of, all this stuff is happening together. The recurring theme for us that I just want to hammer home is education, 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 awareness. There's great groups like NIDIS out there doing a tremendous job helping people understand the potential of representation agreements, but there's a lot more work to be done. Think about the number of people in BC. So that is it for me. It's a race course presentation. I encourage you to look at the paper if you're interested in learning a little bit more or delving more into the issues. We included a lot of stories and examples because I think that they make sense of the theoretical issues I'm talking about a little bit more. So hopefully you'll have a time to take a look at the paper. Thank you.
Hello, my name is Hugh McClellan. I'm a lawyer in Vancouver. About 75% of my practice is the litigation side of wills and estates and elder law, 25% of the planning side. So we see a lot of the problems that arise in dealing with substitute decision-making and the drafting of these various documents. But I wanted to just point out a little bit about the history of British Columbia in this area, because we started this law reform way back in the late 1980s. The laws were proclaimed into effect in 2000, but they were on the books from 1993. So there was quite a long time for people to try and get familiar with our law. And of course, now it's been 16 years since the laws were proclaimed. And yet, we still see many people that don't even know about representation agreements, let alone how to actually do them or deal with them. although we are much better in that regard now. But the other thing that we don't see very much of in British Columbia are cases that deal with this. So, of course, as you know, it's fine for the legislation to state what is supposed to happen, but a lot of times there's a lot of details that the courts end up working out, and we haven't seen very many cases. So one of the thoughts that I had was that we won't see a lot of people giving effect to representation agreements in British Columbia, and whether they're the full-blown representation agreement or a supportive decision-making type representation agreement, until we see some more case law. When the first person that sues a hospital or sues a care facility for failing to follow the person's wishes because they have a valid representation agreement, that's going to open up all the eyes of the insurers for all of these organizations, and they're going to insist that everybody follow the law. And then there's going to be a real push to change, and everyone's going to have these sort of planning tools. But we haven't seen that yet. It's going to come. It will come. There's thousands of lawyers out there that like to sue people over everything, and somebody will do it one of these days. It is a bit of a slow process, of course, because it's taken a while to get that many representation agreements out there. But eventually it will happen, and then as I say, really it's going to open it up. All right, now, how do I move this forward?
Arrow.
Right arrow?
Right arrow.
Bottom right-hand corner.
Bottom right-hand corner? Okay. All right, so I wanted to, well, one other thing I wanted to say before I start is if you want more information, if you want to get detailed cases or references to other materials, this is the resource book. It's called the Annotated British Columbia Incapacity Planning Legislation, Adult Guardianship Act, and Related Statutes. Not the shortest title ever going. It's edited by Robert Gordon, who's a professor at SFU, and in the interest of full disclosure, I am one of the many contributing authors to this, but it is really the best resource. Okay, so representation agreements in British Columbia, as I'm sure everybody knows, you can appoint a substitute decision maker or an assisted decision maker, a supportive decision maker. And in my practice, I find that almost every client that comes to my office that wants a will done, when I tell them about representation agreements, they say, oh yes, I want one of those. I tell them about enduring powers of attorney as well, and they always want those. So it's a rare case where just a little bit of inquiry on the part of the lawyer doesn't result in the client going ahead and doing this planning. I want to point out that many clients will pick multiple or alternative representatives. Again, it's one of these things where you explain to people, all right, it's fine to pick your spouse, but what happens if the two of you are involved in a car accident and one can't act? Oh, I never thought of that. Well, we better pick somebody else. And then they start thinking about who would be the right person to make the healthcare decisions if it came down to it. Also, whether the representatives have to act together or whether they act independently. Sometimes that's a big concern for my clients. They've got 3 children. They don't want to pick one over the others because they think the others will be offended. I always encourage my clients, it's much better to pick one. Just name the others as alternates so they'll say, well, I didn't forget about you, but really, here's the order in which I want people to act. I also, if I do that situation, will often say, as an additional line in my representation agreements, that all of the representatives or alternate representatives ought to be consulted about any decision making. But ultimately it comes down to one person. It's much easier. All right, moving on to advanced directives. These are not really to be considered a general planning tool. They really should be considered in 2 situations in British Columbia. First of all, if clients absolutely don't want blood products because of religious beliefs or that sort of thing, then you know your wishes will never change. That's fine. Do an advanced directive. But really, most people, I think, will be looking at advanced directives if they're being faced with a medical situation where they've been given options. You're going to undergo surgery. you've got a 50% chance of a full recovery, a 30% chance you're going to die on the operating table, and a 20% chance you're going to end up in a vegetative state hooked up to some machines. If that 20% comes true, what do you want to have happen? Obviously, it'll be a lot more technical than that, but that's when you would want to consider advanced directives. They're not really, I don't think they're properly used as a substitute for a living will or just an expression of wishes. So mentioning living wills then, there's really two types. There's a general statement, such as I don't want heroic efforts made to keep me alive. And then we see some living wills that go into great detail about the type of treatment or the type of illness that people want treatment for or don't want treatment for. There is some very limited statutory recognition for those directions in British Columbia, but generally speaking, you don't want to rely on a living will type situation. There are some common law cases, not in British Columbia, but in Ontario, that have resulted in some effect being given to them. Quick example, this lady was involved in a car accident, ended up in the hospital in Ontario. She had a card on her saying she didn't want blood products, so that a living will type situation. The doctor treating her said, I don't know whether this is still her wish, so we're going to treat her. Her daughter came along and confirmed that was still her wish and said she does not want to receive these blood products, and the doctor said, too bad, she needs the blood products to survive. So they gave her the blood products, and she recovered and promptly sued the doctor and won because that was battery. They didn't have her consent to give her those products. Now, she didn't get a lot of money for that, probably didn't even cover her legal fees, but the point is that there is some common law recognition of a person's consent, whether it's by a living will type document or something else. I really wouldn't want to rely on that, however. You're far better off doing a representation agreement in British Columbia. Now, the other problem with living wills is the words that people use in these things. And there's lots of forms out there. You can go on the internet and see what other people use for their standard forms. But you have to be careful because we've seen changes to a person's wishes. They may say what they want today. 20 years later, they may have radically changed their view of life and what kind of treatment they want or don't want, but they've forgotten to change their living will. And similarly, there may be significant changes to medical technology. A doctor told me a story once. He was practicing in a jurisdiction where they did allow living wills, and the person had done a living will at that point with a checklist type thing where they listed the treatment they wanted and the various illnesses they didn't want treatment for. And at that time, there was a health problem, heart problem, excuse me, where you were hooked up to a machine for the rest of your days, and obviously it wasn't a very nice existence. But now they treat it with a pill. Unfortunately, the doctor could not treat the person because they had done this living will at the time when you could have been hooked up to a machine. So, as I say, people don't keep up with changing medical technology. So a representation agreement has the advantage of choosing what sort of decision should be made at the time rather than something you spoke about years ago. So some of the planning issues, it's a good idea to discuss your wishes with your representatives. Some people will write that into the representation agreement or do a separate document. I don't think it's necessary to put it in writing, but it's really important to have that discussion and encourage that discussion, and not only with the representative, but also with the alternate representatives and other family members. There's an issue about where you keep the original of the representation agreement. Do you give it to the representative? My clients do all sorts of things. Some will give it to the representative, some will just hold on to it. In British Columbia, the representative has to sign it. It doesn't have to be witnessed, but it has to be signed by the representative before it can be used. So I generally encourage my clients to have it signed by the representative as soon as possible, so that if there was something that came up in an emergency, it'd be ready to go right away. I also recommend that they give a copy to the family doctor. If people have family doctors, not everybody does these days, but if you do, it can go into the doctor's chart, because often the doctor's contacted if there's some emergency. consider carrying a card. The NIDIS registry, which I'll talk about in a moment, does provide cards, but if you had something in your wallet that said you had that sort of document, that would help in the case of an emergency. And as I say, you can register these through NIDIS, which I'll mention if I have enough time. I wanted to talk about one case in British Columbia that has come up, and you may have heard some discussion of it yesterday, but it's the Bentley and Maplewood Senior Care Society case. This was an Alzheimer's patient who had been a former nurse, and she was in a care facility being spoon-fed. She had done a pre-2000, so prior to our law that would allow you to do a representation agreement, living will that stated she didn't want heroic efforts made to keep her alive, and she didn't want to be kept alive by artificial means, and she also had specified she didn't want to receive nourishment if it came down to that. The facility was asked by the family to stop feeding her because that was her wish. They refused, so the family went to court. I'm not going to talk about many of the aspects of this case. It's a very interesting case. I just want to focus on what the court had to say about the living will that she had drafted. The court found that the words that she had chosen were ambiguous. Her overriding wish was that she would have no heroic efforts made to keep her alive and that she would not be kept alive by artificial means. So even though there was a specific part in her living will that said, I don't want nourishment if it comes down to it, the court said the heroic efforts overrides everything else. And feeding someone is not a heroic effort and it's not artificial. So her wishes, I think, were not followed in this case. The court also said that the living will was not a representation agreement or an advance directive, and that an advance directive cannot deal with personal care. The court found that feeding was personal care as opposed to health care. So they also raised an issue about whether, under our abuse and neglect provisions of our Adult Guardianship Act, anyone could ever stop feeding a person. And there's certainly some question of that, and perhaps we need a legislative response. So finally, I want to mention the NIDIS Personal Planning Registry in British Columbia. This is set up through a not-for-profit organization. They have a 24/7 online registry, so people can either download their planning documents or just register and say, I've done a representation agreement on this day, and here's all the contact information for my representatives. They charge $25 per document, but their website, I would really encourage you to take a look at if you have any other interest in this area, because they do have a lot of other resources in there, not only just for registration, but also ideas for planning and how to deal with your documents. Thank you.
Thank you. So I'd like to thank the organizers for asking me to participate in this panel. I'm slightly off in this panel because I'm coming from a different angle, but want to bring up some of the practical issues that really occur. And as a practicing oncologist, needless to say, I do see people, a lot of people who are elderly, a lot of people dying of their disease. So I'm coming at it from that angle. What I really want to talk about today is a little bit about the scope of the problem related to serious illness and death, the shared care issue. So supportive care or shared decision-making, you also have to factor in when you're talking about health care, who else is involved in that healthcare planning. Some of the issues that I see with patients and clients around autonomy, independence, and the issues around family, some of the personal issues such as education, belief, ethnicity, and language, as well as just briefly talking about some of the societal and healthcare delivery issues such as access to care. So to bring some color into the slides, we'll just look at this. But one of the reasons to look at this is to really see that cancer right now, this is from 2011, and those numbers are only going up now, but it accounts for about 30% of the deaths in Canada. And why is this important? If you look at it, cancer is generally a chronic disease. Very few people die of the old saga of they found cancer and died. People have a long period of time, and in that period of time, there are opportunities for dealing with shared decision-making for supportive care. If you look at other things such as kidney disease, Alzheimer's, other things there, diabetes, those are also chronic. So the issue about people getting this together, people have time, and it's not just needing to come from the lawyers when people come in to get wills, but it's obviously the responsibility of the healthcare professionals as well to bring up this issue, something that is poorly done. So when I talk about healthcare, I'm coming from a cancer point of view, and I just want to bring up that one of the things with cancer is there's always a fear, there's a lot of metaphors around cancer, there's a lot of literature. There are a lot of cultural beliefs of cancer. Gloria was talking earlier about people needing to suffer before they die in some belief systems. And certainly cancer has a lot of different beliefs. The people who blame themselves, blame others, need to suffer, don't want to talk about it, it's a shame. Or then there are the other people who want to talk about it all the time, but maybe don't want to talk about the real issues around it. So it brings up a lot of issues. For seniors, what's important is the risk of dying of cancer, you can see for males 80 to 89 is 16.5% in these statistics. So it's fairly common. And the reality, as I said, of cancer is it's often a chronic disease. It gives time for people to talk with their network, to talk with their support network, as we've heard about, and to get in place these opportunities for shared decision making. Just to give you some other statistics, in 2015, close to 200,000 people were diagnosed with cancer, and about 78% of Canadians died of cancer. As well, there are over 800,000 people living with a diagnosis. So this is common. It's not a rare thing. And it is an ability, it is one sort of framework to talk about how we can use shared decision making. One of the issues that's already been brought up is ethnic differences. And one of the things that's important is within ethnicities, there's obviously differences too, but there are some very broad strokes about how illness, death are viewed by various cultures and religions. There's huge differences around end of life. Can it be talked about? Can it be brought out? Can it be discussed? There's issues of veracity, and increasingly we need consent from patients. Thank God we need consent now. But who consents? Who needs to know the truth? And it's less rare now than it was when I was training or early in my career for families to say, don't tell mom she's got cancer. But that still does happen. And how can you have consent or shared decision making when there's no veracity? We obviously need to respect differences, but the healthcare provider may not appreciate the differences. So very often, as the healthcare providers, we may stumble in our framework, how we think it's best, not being sensitive to the cultural differences around death, around disease, and around how the timing of these discussions has to happen. We want people to fit into the Canadian perspective, and indeed to develop and to deliver the care we want, often people have to fit in, but is that the sensitive way to approach it? The other thing that happens if we're talking about seniors is when you're talking about cultural and ethnic differences, there may be a big divide between the seniors and the younger people in the family around those cultural differences, particularly if there's an immigrant family where people might be holding on to things that they arrived with, whereas the children, the grandchildren, and often the people making those shared decisions no longer hold on to those beliefs. Language is huge. Increasingly in BC and around the world, there are particularly seniors where English is not their main language of communication. And here we are talking about very sensitive things, end of life, death, shared decision making, illness, and we're not doing it in their primary language. There's an issue that there's often substituted care without the consent. So the person without the language may be agreeing to substituted care without really agreeing, just by virtue of their language isolation. And sometimes there's a question of, is there a direct translation for some of the concepts? We know in some languages there aren't the same words, but there certainly are different nuances to how we say things. If I say someone has a mass, I maybe be talking about a tumor or a cancer, but a mass may be described in a translation as a lump or a sphere that has nothing to do with disease or cancer. And the confusion can get quite profound. At many healthcare facilities, we now use interpreters, but one of the questions we're always asking is the information accurate? I believe interpreters are giving more accurate information than a family member, particularly if it's a grandson of an elder person, which used to happen more, but we don't really know, is that information accurate? And the other problem as the healthcare provider is we can't always assess what the person's understanding from that translation. So the translation may be clear, the answers we get may be clear, but the nuances and the understanding may not be. The other thing is there is the family protection of information. And this is less common and less available as we have translators, but there still is a huge issue of protection. And again, if we're talking about the fact that the family is often the supportive care decision makers, that control of the information is important to acknowledge and to figure out how we deal with it. There's communication challenges with healthcare directives, and this is a really huge point, and probably the most important point that I'm going to bring up is, although Hugh and Krista and others can talk about people having representations, most healthcare providers don't know that there are those representative agreements there. And most of us don't ask. Why don't we ask? It's not part of what we're doing a lot of the time. So somebody may get a healthcare directive. They may give it to their substitute decision maker. They may give it to their family doctor. They may then end up in the hands of specialists, other healthcare providers, homes, somebody else who has no knowledge of those. And this is particularly true as people have less association with their family physicians or no family physicians, or as people have more disparate lives. So I see a lot of people who I can see over years and years, and I do talk to people about this. I do often ask them, do they have wills? Do they have supported shared communication directives, all of these things? And it's interesting how few people, even with a diagnosis of cancer, have thought about these things, first of all. And secondly, if you ask people if they have them, either they don't know where they are, or they're with somebody who is no longer in their sphere. They're with their family doctor in Fort St. John, and they've moved down to Vancouver, and we don't have them. Now, obviously, there are some things that are NIDIS and other things that are coming along, but this is really important to know that although care is distributed, and patients often don't remember the names of their care providers, let alone where they have left these things. So getting these electronic, getting more discussion about this, getting education pieces, getting it talked about more is what's important. People usually come into an office with a friend, even that friend knowing where these things are. So this is, I think, I'm taking responsibility as a healthcare professional that we have to be more involved here to get people out to know about this, because this shared communication really causes challenges. Access to information and education about substitute care. There is information we've heard, but many people don't know about that. And when people come into a healthcare facility, the information is usually about their disorder, about the medications, about the resources for care, and these things fall off the wayside. The issues around supported care or directives are often not there. So what do we need? We need education material that's not fragmentary, that's not contradictory, and that's suitable for the person receiving it, and often we don't have that. Increasingly, my patients are going to the web for information around this, and a lot of the stuff on the web isn't Canadian-based, and they often don't go to the Canadian sites. So people come in with expectations of living wills or other things that are not appropriate for our system. There are disparities in care in BC and in Canada, and varies with the needs. So there's disparities in how many people have family physicians, specialty, there's manpower issues. Access into the system is often an issue. For many people, once they're in the system, it's not a problem, but access into the system. So people are out there with healthcare problems who need to have these things in place, but are not in the system. Knowing how to access the system is important. And a lot of people believe there's more process than there is sometimes. And this was already spoken about in terms of the healthcare directives, of the fact that they might have written a living will, but it doesn't really reflect what it is. People have more belief in some of their systems than possibly they should. So there's a lack of adequate, well-advertised resources for supported decision-makings, at least within the facilities that I'm in. Sometimes there's issues of trust, and that can be related to the prior experience with the healthcare system, and it may impact people's trust and understanding, and therefore their ability to discuss their healthcare needs or their supportive care decision-making needs are not there. That can impact culture, And there can be a danger in too much trust or too little trust. You know, I signed that form, everything must be in place, but as Hugh talked about, not updating it to what the current issues are. So too much trust or too little trust are also important. Difficulties in overcoming a lack of trust may lead to inadequate care. So I see many people who've had bad experiences, who are battered by the system or some other issues, who don't have trust, and then who delay and delay and delay dealing with these issues until really they're not in a position to deal with them. So what steps can we make to improve? I think first of all, we all have to introduce the whole idea of substitute or supported decision-making early in the course of a relationship between healthcare providers and clients. And as healthcare providers, it's important we bring this up and we steer them to the lawyers and we steer them to the places where they can go, because we do have access to that. And again, as I say, I see people with end-stage cancer often who I've talked to them for 4 years about, do you have a will? And they say, no, I'm getting to it. But it really needs to be brought in earlier because it often doesn't happen. It has to be culturally sensitive, available, and we need translated tools. We often don't have enough translated tools around these issues. I think we need to involve family support system, patient-client, even when they're independent and not in crisis. And this is again the story of the patients I see who I know are going to get into crisis along the way. And my job is to promote their good quality of life for as long as I can. But in that time, they need to get these things in place. And often they're out of the place where they can make the consent and make the right decisions by the time they get to that. They're either too ill or lacking cognitively or other issues. And the family issues often don't know. I often know what a patient wants from having spent years with them. But when it comes to the end, there's disputes because they haven't put it into place. Communication in this aspect of care has to be also part of medical charting so that the communication between different healthcare providers is not there between different healthcare facilities, and that's really not in place now. So thank you for your attention, and I'm sure we'll have lots of questions.
Thank you, panelists. You did an amazing job of staying on time, and we have a few minutes for questions. So if anybody in the audience has questions, I ask that you go to the mic, please, as this is being taped.
Sorry, my name is Al Gina. I'm with Park Place Seniors Living, and we manage care homes in British Columbia and Alberta. My question is for the moderator, Jennifer Davenport, and I just want to take advantage of the fact, even though my question relates to our next session, Forward Financial Planning and Protecting Against Elder Abuse. And my question for you as a Deputy Public Guardian and Trustee is this: why is the PGT failing seniors in residential care who are facing financial abuse from their own children? Increasingly, we are seeing seniors in residential care fall thousands of dollars into arrears because their children cannot manage their financial affairs, either purposefully or because of a lack of capability. The PGT is not stepping in, and as care home operators, we are then faced with having to evict vulnerable and frail seniors from our care homes for non-payment. You know, I understand the PGT has a policy of taking the least intrusive approach, but this policy is not working for seniors in residential care. When the PGT says least intrusive approach, what care home administrators hear is the PGT saying we will sit on our hands and do nothing. So if you can please give us some comments on that, I would be very appreciative.
Well, Al, as you know, this is a complicated topic, and there's been a lot of discussion between our office and your group about this. And I'm just going to say something very briefly because really I want to focus on the panelists here, and that's the issue of taking committeeship over somebody is a very intrusive measure, and there has to be a very fulsome review and to determine whether it's appropriate for that measure to be taken. And oftentimes there are other ways that your issues can be dealt with. So, I'd be happy to talk to you about that offline, but I think I prefer to answer questions for the panel. Thanks.
Good morning, and thank you for this. My name is Catherine Willett. I work primarily with family caregivers who I must say find most of this clear as mud, if not totally muddy. And it's taken me a few years myself to understand the very basics. Two things is, well, I'm living with cancer myself, and I found it very interesting what the BC Cancer Agency oncologist mentioned, because I was quite surprised myself. When I first became a patient with BCCA, I was given some books to read about my type of cancer and a little pamphlet about the publication My Voice. And it was quite interesting because I said to the nurse, "Oh, well, do you have a copy of My Voice?" And she said, "No, but you could probably find it at a library." And I must say I was really quite shocked that this was happening at BC Cancer Agency. But you know, it happens everywhere. And one thing is certain, we have a lot of education to do in very plain language. So my comment, if you wish to comment, is about the Ministry of Health publication called My Voice. For those who haven't seen it, it's 52 pages long. Some paragraphs read beautifully, others are clear as mud, and as was brought up at last year's BC Palliative Care Association meeting, even a lot of the volunteers with different hospice associations don't understand it. I was speaking with a social worker at one of the hospitals who one day was crying. She's a friend of mine, and she said, "You know, we're supposed to speak to patients about this, and we've never even been trained." I heard a doctor ask once at a meeting, "So once we have a person, help a person fill out an advance directive, where do we fax it?" And of course, there is no place to fax it. So I found it just fascinating that none of you talked about this 52-page publication. The ministry has printed millions of them, and yet it's a problem document. And so why wasn't it mentioned this morning?
Thanks very much. Maybe next time we need to have somebody from the Ministry of Health. Does anyone on the panel have a comment?
So I think you've brought up, something important. I think there is some good material in My Voice, and I actually thought about whether I should bring it up, but I think one of its problems is it's 52 pages. And as I think I mentioned, you have to do things in steps. And I think what we're lacking is a briefer, summarized version of the steps you need to take. And I also think the problem with My Voice is it goes too quickly to that end of life place. So a lot of healthcare providers are reluctant to give it too early to a patient because we're always balancing hope and reality and what's going to happen. And people often feel uncomfortable with that. So I think what we need, and there are some people putting together, I know it at my institution, something that's a smaller, succinct document that's starting that first step. So the first step, not necessarily jumping to this is your end of life, but saying these are the things that we all need to have in place.
Thanks very much, Karen. I know there's going to be quite a line here, and we only have about 8 minutes, and I don't want to cut into the next presentation. So if you could keep your questions short, I'd really appreciate it.
Okay. I think this probably is for our doctor on the panel. Are you familiar with the MOST form, medical orders for scope of treatment, that I understand is used a lot in residential care, especially for transfers between residential care and the hospital? And I'm wondering, I'm assuming it's somewhat like, I've seen it. It's something like advance directives, but it's not a legal document, it's a medical document. The reason I'm asking about this again, because I asked about it yesterday, is I'm still confused. So if you could comment on that form and how it's used. So
I know how it's used personally because I went over it and signed it every year for my mother and father for years when they were in a care facility, and looked at the different levels. And how it was also often used was my siblings and I had to talk about where we were at because we needed to communicate to have a joint view. As you say, it's not a legal document, and I think it is something in the step of what we're talking about of levels of care, but it's not a legal document. So, and it's not used outside of care facilities. It's certainly not used for ambulatory people.
And is it related, did you find in your circumstance it was related directly to advance directives? Did your parents have those legal documents in place as well?
So my parents both had dementia near the end, and they both had those documents in place long before, for a number of reasons. I'm related to Gloria. We obviously knew about gerontology, but also because we knew that we needed to have those things in place. So they had those already in place.
How would people find out about that form and make sure that it's been filled out for a loved one that is either close to the end of their life or is very ill? Can you take steps to have that done?
You know, I think that probably what we need, though, are the legal documents for most. So I think the problem with that document is that it's not a legal document. I do think what's good about it is if you're reviewing it constantly, you don't run into the problems that Hugh was talking about of changing attitudes or changing technologies. So, you know, it might be that it's something that we should be putting into healthcare for everyone on a constant basis, but that would assume that we all access our primary healthcare, deliverables every year or something. So I think that there is a place, and I think you bring up a good point, but I would like to see a document like that be a legal document so it would be binding.
I think it's a stopgap at the moment.
Yeah. I don't know if you have something.
I just wanted to add in that I agree, these are not legal documents, and whether it's a DNR order or that somebody signed on behalf of somebody else or one of these ones you've just mentioned, they're not legal documents. They really should not be used, and it annoys me that the healthcare industry keeps producing these things. You need to get a legal document. If you have the representation agreement that allows you to make those sort of healthcare decisions, yes, you can fill in the form and then it works. But just to have one of these forms and think that you've done it properly is a mistake.
Well, the one that I've seen, in fact, the representation agreement is both mentioned, and the person who is named has to be named on the form. Now, I'm not sure if they have to sign the form. And it's signed also by the family doctor who is supposed to consult on this form. The form is to do with what you do and do not want done to you if you end up in the hospital. Do you want to be intubated? Do you want, all the different treatments?
And it's not legally effective.
It's not legally.
No legal effect.
Even though the representation agreement is mentioned or the person.
You can't pre-consent to things under our existing legislation unless you do an advance directive, and there's a specific form for that.
Interesting. Thank you.
I wonder
I'm
if we
still
could...
confused.
What is the legal relationship between advance directives and representation agreement? I have both, but I was advised that there is no way of legally attaching my advance directives. So that's one part of my question.
They are separate documents. Yeah.
But my decision was to give to everyone who is getting representation agreement my directives. Would they be able to use them?
Yeah, you can certainly circulate those to whoever you wish, and I don't want to discourage people from expressing their wishes through My Voice or any of these other documents, because that's important that everybody knows what your wishes are, but you also have to make sure it's going to be legally effective.
Mm-hmm. And the question, another one is, I have those documents, and I don't have special documents for substitute decision making because I haven't found any on the webpage in existence.
Not.
So supportive and substitute are two different.
Substitute is you can have a representation agreement,
right?
And you can appoint your representative to make your decisions, which is substitute, or assist you, which is supportive. And that's what Krista was saying. It's confusing because the same document can make the representative substitute or supporter or both.
Mm-hmm.
So,
okay, thank you. And in advance directives, what wording I should have there to ensure that I wouldn't be fed forcefully? in the light of the case.
I think we're getting into the area of legal advice.
We're still waiting for the
No, but
case that
it
tells
applies
us
to lot-
exactly what will work, because we've seen what doesn't work. So I'm sorry I don't have an answer.
So you have no recommendation what language I should have that?
Just do a representation agreement.
Well, I have it. Okay, thanks.
Good, thank you. And I think we really only have time for one more because we're out of time and we're going to be moving into the overtaking the next session.
So I'm Melinda. I'm from Northern Health, and I'm the adult guardianship lead in the North. And I always love these conversations where we have the intersection of law and health, like that, because that's exactly what we're talking about. So I've been asked, and I really love this document that you've produced and shared with us around the complexity of capacity assessments, because it's so very complex. I've been asked to speak at the university in the North on Friday to a new group of nurse practitioners who are being asked to learn about capacity assessments. And so as part of our, I'll be doing that with my geriatric physician colleague, because as you know, or as I imagine you know, our physicians are being asked every day to assess capacity. And so they've been giving us 2 hours to talk about capacity assessments. So I will certainly share this document, but I wonder if you have any advice if you had 2 hours to talk to NPs about capacity assessments.
The guide, Allison?
Yeah, the
guide?
the public guardian and trustee has the very thick guide on how the assessment process works. It's a lot of material, but you can get maybe some ideas out of that.
I mean, I really appreciate your messages around every capacity assessment is different, and what's the purpose and what's the decision and what is the outcome we're hoping to achieve. Sometimes it's healthcare, sometimes it's finances. It's all very different, but I really think that I was hoping for a couple of very key messages to this brand new group of grads.
I mean, I think we often hear, capacity is a legal test, and the lawyers have, when a physician is being asked to give an assessment, they need to be told what the test, what kind of capacity are you assessing for? Is it to make financial decisions? Is it to decide where to live? And that's where, I don't train doctors. I haven't trained doctors. That training happens out there, but I think where the things fall down is when the lawyers and the practitioners aren't being clear on what test you're trying to address this time. Right. And financial capacity depends. If all I have is CPP and old age security and I pay my rent, my capacity needs are much different than running a $2 million investment portfolio in a business. So even within that, it's what are you trying to manage? Can you do it? And I think the guide for the court, Allison, what's it called? Court.
I have it. I know what you mean. Yeah.
The certificate, the guide for CII guidelines that was put together by the health authorities and
I think
the PGT.
ultimately we need to just remind ourselves that this isn't an easy, simple process or conversation. So 2 hours is not going to be enough. Thank you.
Allison, like 1 minute. 1 minute.
I just wanted to let everybody know the public guardian and trustee has an excellent publication called It's Your Choice.
Yes.
It was written by Kathleen up there. And I'm going to see if I can arrange to get some copies over the break. I don't know if I'll be successful. If you want to be on a list for me to email you the link, I will definitely do that. I also wanted to let you know, and I don't want to steal any thunder if there's people from the BC Centre for Palliative Care here, but they are revising my voice. I don't know if that means it'll be shorter, but there is a process underway to do that. I think if you want to know more about where that's at, you could contact them. And also, I think there's a lot of work being done by them to figure out how the most fits in to all of this, and also a lot of work being done to figure out how to educate both community members and healthcare providers. So I just wanted to let people know those things, and also to remind people that NIDAS does produce excellent educational material. Thanks.
Thank you, absolutely. And Gloria, I'm so sorry that I've let this go over, but thank you all for coming out this morning to hear this very interesting topic from these really wonderful panel members, and thank you all for sharing your knowledge.